When a Vietnamese company owes your business a large amount and shows no real sign of repayment, a natural question is, can we force them into bankruptcy? And can bankruptcy be used as a tool to recover what's owed? Vietnam has a bankruptcy law, but it is procedural, document-heavy, and often misunderstood, especially by foreign creditors. In this video, we'll explain when bankruptcy can support debt recovery in Vietnam, what it realistically can and cannot do, and how to decide if it's the right move. In Vietnam, bankruptcy is a court-supervised process under the law on bankruptcy. A business is generally considered insolvent if it fails to pay a due debt for 3 months from the maturity date. Creditors may petition the People's Court to initiate bankruptcy procedures, which can lead to court oversight of the debtor's assets and liabilities, meetings of creditors. And, if recovery is not feasible, liquidation and distribution to creditors according to the legal order of payment. Importantly, bankruptcy is not the same as voluntary dissolution under enterprise law. It is a collective insolvency process managed through the court system. Yes, under Vietnamese law, an unsecured creditor or a partially secured creditor, including a foreign company, may file a petition after 3 months from the due date if the debtor has not repaid. What matters most is your evidence file: a valid debt, clear due date, proof of performance or delivery, and proof of non-payment. This is not a casual threat. It is a formal court procedure, and the court will expect proper documentation and correct jurisdiction. Bankruptcy can be useful when the debtor is truly insolvent and creditors risk being played through delay or selective payments. Because bankruptcy is court-supervised, it can increase transparency and reduce unfair asset movements through the formal process. It may also help prevent a scenario where one creditor gets quietly paid while others are left behind, especially when the debtor's financial distress is real and escalating. That said, bankruptcy is not a magic button for instant repayment. It is best viewed as a strategic tool to manage insolvency risk and protect recovery options in a structured way. Bankruptcy is not always recommended. If the debtor has no meaningful assets, the expected recovery can be minimal. If banks or other secured creditors hold most valuable assets as collateral, unsecured creditors may recover little or nothing after priority payments and bankruptcy-related costs. And bankruptcy proceedings can take many months or longer depending on complexity, disputes, documentation, and the number of stakeholders. In some cases, a targeted negotiation strategy, civil litigation, or enforcement-focused steps may be more practical. Litigation is typically used to resolve disputes and confirm liability on a specific claim. Bankruptcy is designed to address insolvency risk through a collective procedure. Sometimes they can be used in parallel or in sequence, depending on whether the debt is disputed, whether assets exist, and whether creditor coordination is needed. The key is strategy, choosing the route that matches your evidence, your speed requirements, and the debtor's real asset situation, rather than choosing based on emotion. A foreign service provider faced a large unpaid balance from a Vietnamese counterparty that stopped communicating. After demand letters and stalled negotiations, the creditor prepared a bankruptcy petition dossier and issued a formal notice of intent to file, supported by key documents and a clear timeline. Within days, the debtor re-engaged and proposed a structured settlement plan with additional security. The bankruptcy filing was not ultimately necessary. Details adjusted to protect confidentiality. The lesson: bankruptcy pressure can work when it is credible, because the dossier is ready. At LTS Law, we treat bankruptcy as a strategic option, not a default step. We start with debtor profiling and asset reality. What assets exist, what is secured, what is collectible, and whether bankruptcy is likely to produce real distribution. We also prepare a court-ready dossier with supporting evidence and, where appropriate, bilingual documentation to reduce misunderstandings and procedural friction. When bankruptcy does not improve recovery probability, we recommend alternatives. Bankruptcy filings are procedural and detail sensitive. Petitions can be delayed or rejected due to jurisdiction mistakes, incomplete evidence, or missing formal requirements. The process can also become visible through formal steps, so it should never be used casually. Foreign creditors should plan carefully with local counsel to avoid wasted time and unintended leverage loss. Bankruptcy is not just a legal decision, it's a recovery strategy. If your debtor in Vietnam is insolvent, unreachable, or using delay tactics, speak with LTS Law. We can evaluate whether bankruptcy, litigation, negotiation, or enforcement-focused action is the best path, then execute with a disciplined plan. Visit lts.com.vn to book a strategy session. In Vietnam, the right legal move can turn a dead debt into a recoverable outcome.